Biden Title IX rule. My name is Teresa Manning, and I am the Policy Director at the National Association of Scholars and also the President of the Virginia affiliate of NAS. I am delighted to have with me today Christian Corrigan, who is the Solicitor General of the state of Montana and also the Assistant Attorney General, more importantly, the author of a recent complaint filed in federal court against the new Biden rule. There are right now a total of 9 lawsuits against this rule, 8 of which have states as complainants, representing 28 states total who are formal plaintiffs in this litigation. So today, the structure of the webinar is going to be that I will speak for the first 10 to 15 minutes to provide some background on Title IX. Thank you for indulging me with that. But I think without that context, this area of law can be quite confusing, as it involves a congressional statute, executive agency rules, court decisions, and of course, multiple administrations. Then I will hand it over to Christian, who can brief us on the state of the litigation, including the particulars about the complaint that he has filed, what that complaint is alleging, how that complaint might overlap with the other lawsuits or how it might differ, and what he thinks might happen with the litigation specifically if the rule might be prevented from taking effect. And at that point, we will welcome questions from the audience. This webinar is being recorded, so if you need to leave early, you can see it on the National Association of Scholars YouTube channel. I do prefer to take questions via chat rather than the question and answer function, because the question and answer function blocks my screen. So thank you in advance for that. And thanks also to Kaylee Gerard, who is providing us with technical support today. For my background, I hope to answer the following questions. What is Title IX? How did bureaucrats in Washington, D.C. and on campus change Title IX? What happened under President Trump? What is happening under the Biden administration? And where do things stand now? In addition to my remarks, I will refer people to the publication in 2020 by the National Association of Scholars, the booklet and report called Dear Colleague, the Weaponization of Title IX. A lot of my remarks derive from that content, and there are more citations and particulars about the background for those interested in that report. So what is Title IX? Title IX is a 1972 congressional statute forbidding sex discrimination in federally funded education. It actually creates a contract between the federal government and schools that they can receive federal funding on the condition that they promise not to discriminate based on sex. The document that contains that contract is called the Program Participation Agreement, or PPA. Title IX, at the time it was enacted, seemed benign. It is an outgrowth of the civil rights era, where equal opportunity laws and equal access laws were quite popular, especially for ethnic minorities or Black Americans. The feminist movement piggybacked somewhat on that. This was an extension of those laws banning discrimination based on sex. And though that is the wording of the statute, at the time it was understood this was mainly to guarantee equal access to education for women. However, over the years, the statute expanded. How did it expand? The answer is bureaucrats in Washington, D.C. and also on campus. For the Washington, D.C. bureaucrats, we are talking about the civil servants in the federal agencies or the executive branch. The executive branch makes rules or regulations to implement federal laws. That process of rulemaking is governed by the Administrative Procedures Act, or the APA. The idea with executive rulemaking is that the agencies will fill in blanks, particulars that are left open by Congress, not major questions of policy, but particularities sometimes specific to expertise in an industry or a sector. So for example, the Environmental Protection Agency might get to decide how much of a toxic substance could threaten the environment. When Congress leaves these areas blank, there's always a risk that they're leaving something major blank, which runs the risk of executive agencies then overstepping their function and beginning to make policy. This is a no-no because Article 1 of the United States Constitution confers only to the legislature, that is the United States Congress, policy-making or law-making competence. I would call this congressional abdication. Sometimes it is called congressional delegation. And when the courts decide that Congress has unduly delegated certain powers, it is called undue delegation. The agencies have recently, by which I mean in the past 20, 25 years, begun to assume much more power with their rulemaking, and the courts are beginning to find that agency action is indeed overreach. And actually, for the Environmental Protection Agency, the United States Supreme Court in the summer of 2022 invalidated an EPA rule on the Clean Water Power Plan, I believe it was. And also, the Supreme Court invalidated a Biden rule on student loan forgiveness as overstepping the bounds of the executive branch. In the Title IX space, bureaucrats have expanded Title IX mostly through redefinition. So, for example, the word discrimination back in the early 1970s was mostly understood as what's called quid pro quo propositions. That is, if a professor were to demand sex in exchange for a good grade, that would constitute sex discrimination within federally funded education. But over time, the courts and litigants devised a concept called hostile environment, which is a much more nebulous category of discrimination. And the Supreme Court actually has tried to cabin in the definition of hostile environment by ensuring that it be hostile by objective standards. And the last time the Supreme Court has ruled on Title IX, I believe was 1999 in the Davis versus Monroe case, where it decided that only a severe, pervasive, and objectively offensive conduct could constitute a sex discrimination, depriving someone of access to education. But the bureaucrats in DC, piece by piece, with baby steps, began to expand even this nebulous hostile environment category, and most recently have introduced subjective perceptions of hostile environment, which of course is a moving target and raises due process concerns in the sense that people may not know what conduct would constitute illegal sex discrimination. Most recently, the Biden administration is now attempting to redefine the central term of the statute, sex itself. Agencies not only promulgate formal rules or regulations pursuant to the Administrative Procedures Act, or APA, they sometimes also write letters. The legal status of these letters is actually something of an open question, since this correspondence does not observe the steps prescribed by the Administrative Procedures Act. In the Title IX space, the most infamous such letter was a Dear Colleague letter issued in 2011 under the Obama administration, which simply asserted that sexual violence was a form of sex discrimination now banned by Title IX. This had a number of issues. I'll only note that violent offenses are a matter of criminal law, and criminal law mostly at the state level, not at the federal level, even though we do have the Violence Against Women's Act, but the same comment could be made there. And certainly not made into a federal offense, not only by the federal government, not only not by a rule, but in correspondence called a Dear Colleague letter. That 2011 Dear Colleague letter also reduced the standard for finding accused parties guilty or having committed sex discrimination. And this ushered in the era of what we call campus kangaroo courts. The federal official to oversee that chaos was actually Catherine Lehman, who is right now, again, in that very same position of Title IX czar in the Biden administration. That kangaroo court era resulted in hundreds of lawsuits where accused parties, mostly male students, claimed that they were railroaded by campus officials and did not receive due process, but were branded as sex offenders, often suspended or even expelled. And for those interested in the nightmare that this represented for many students, you should see the National Association of Scholars webinar, Title IX, The Good, the Bad, and the Ugly, where we feature just such a wrongly accused student. Due process became a major concern, therefore, in the Title IX space. What is due process? Due process is also defined as fundamental fairness. It refers to a basket of rights that protects typically a weaker party when faced with the strength of the state or another institution in a formal proceeding. It includes the presumption of innocence, the right to know the charges against you, the right to confront your accuser and to question witnesses, and the right to appeal. Significantly, another aspect of due process is that you must have impartial decision makers. And in the kangaroo court era, under the 2011 DCL, one of the most egregious aspects of these adjudications was what's called the single investigator model, where one single campus official could serve as police, judge, and jury in prosecuting and convicting an accused student. This is already a flagrant due process red flag. So what happened after the campus kangaroo court era? Trump was elected and his Education Secretary Betsy DeVos inherited this chaotic mess. To her eternal credit, Betsy DeVos tackled this problem, formally rescinded the 2011 Dear Colleague rule, and began the Dear Colleague letter, and formally began the process of promulgating a new rule of formal regulation under the Administrative Procedures Act. That process began in 2017. It was concluded in 2020, and that rule restored due process protections for those accused of Title IX offenses, the presumption of innocence, live hearings at the college and university level, and impartial decision makers throughout. Every court to review the DeVos rule upheld it as lawful and fair. But what happened after that? The Biden administration. And out of the gate, the Biden administration targeted the DeVos Title IX rule, even though by all indications it appears to be working just fine, and 3 years of blood, sweat, and tears were invested in promulgating it. Biden also nominated Catherine Lehman to again serve in the role as Title IX czar at the Education Department. The Biden administration this time, however, issued a formal rule, that is, they followed the Administrative Procedures Act, which requires steps such as a draft rule, a proposed rule published in the Federal Register, a period for public comment, and then issuance of a final rule with explanations of how the final rule represented deliberation or consideration of objections made during the public comment period. The new Biden Title IX rule is bad. It guts the due process protections that Betsy DeVos restored, primarily, in my opinion, by returning to the single investigator method of adjudication, which is now called the individual meeting method. So we have the same substance, just going by a different name. Whenever you have fraught, emotional, and consequential issues to be resolved in a procedure, formality is your friend, because formality guarantees that people will not play fast and loose with the facts, with evidentiary rules, and preserves a record for appeal. However, the individual meeting method does not require a transcript, does not require a formal hearing. It is giving a much more relaxed way of resolving these issues. In the National Association of Scholars report from 2020, one of the main findings was who is staffing these Title IX offices? And it turns out that they are overwhelmingly staffed by ideological campus employees. 90% of these people come from women's studies or gender studies, and therefore appear to have an axe to grind when it comes to allegations of sex discrimination and certainly allegations of sexual misconduct. So on the due process front, we have a very bad development with the Biden rule. And I am somewhat concerned that the due process aspects are now taking a back seat to other problems, because people have probably heard that the rule also redefines sex itself, which I mentioned earlier. It redefines sex to include gender ideology and same-sex orientation. What does this mean? This means that transsexuals or transvestites claiming to be a sex other than their own can say that the new Biden rule means we are all forced to use pronouns that they demand, or they must, by legal right, have access to locker rooms or bathrooms or athletic teams of their choice. This is also a bit confusing because there is a second Title IX rule in the hopper specifically regarding athletics. And the Biden administration has attempted to say that the athletics issue will be delayed until that rule emerges. But in point of fact, this rule that was just issued in April can certainly be used by transsexuals attempting to participate on athletic teams where they don't belong. Similarly, the inclusion of same-sex orientation means that those with moral objections to homosexual conduct can be silenced now by the Title IX rule, that their speech can constitute a Title IX offense under this rule. Obviously, the new rule raises many issues, including constitutional issues such as the individual rights of First Amendment rights of free speech. And I would say religious exercise, since one's religious faith can inform one's view of sexual ethics. What's happening now? America is not rolling over about this Biden rule. We are thrilled to see that the states are stepping up in stopping the Biden administration and this obvious overreach. I say overreach in part because sex is so central to this statute and gets right into the policy-making, law-making function that belongs exclusively to Congress. As I mentioned at the beginning, there are 9 lawsuits that have been filed against the Biden Education Department, representing 28 states. And we have with us today Kristen Corrigan, who filed the complaint in federal district court in Louisiana on behalf of the state of Montana. He's the Solicitor General there. And I'd like now to turn it over to Kristen so that Kristen can tell us a little bit more about these lawsuits, specifically the complaint that he filed, how it overlaps or doesn't with the other complaints filed against the administration, and what he thinks might be happening this summer. Kristen.
Well, thanks very much, Teresa, and thanks to the National Association of Scholars for inviting me. I really appreciate all the work that you do and what you stand for. And thanks for that very helpful background. That was great. It means I have to talk less, which is always a good thing. So I don't have to set the table. As just one more piece of background before doing this job, I was senior counsel at the Office for Civil Rights at the Department of Education for Secretary DeVos for 2 years, and I was heavily involved in writing the 2020 regulations. So just a disclaimer there that in addition to agreeing very much with the goals of Secretary DeVos, I helped write them with folks like Ken Marcus, who some of you may know. And before that, I sued the federal government for a living. So I've sort of been on both sides of rulemakings now and currently sue the federal government at the same time that I defend suits against the state. I think as Teresa noted, we've been working on and preparing for this lawsuit since January of 2021 when President Biden took over. We knew this was coming. VP Biden actually led the Obama task force that created the 2011 Dear Colleague letter, the 2014 Q&A, and he campaigned on reversing the Trump-DeVos rules. And they tried to impose this in the summer of 2021 via what's called a notice of interpretation and a fact sheet. And my state got together with 15 other states and filed in federal court in Tennessee and got those guidance documents enjoined for our states. But of course, we all knew they were going to go for a full-on rulemaking because those aren't susceptible to the same types of challenges as the sub-regulatory rulemaking documents are. So we've been preparing for this. We commented in accordance with the Administrative Procedure Act. We sent multiple letters. We participated at every turn. And I think one of the interesting things about this is when I took over at the Department of Education, it was very heavily geared towards the due process and the grievance procedures. And over the last few years, because of the issues relating to gender identity, the interest in Title IX has just ballooned. And as Teresa mentioned, and I'll talk about it a little bit later, the grievance due process procedures have sort of taken a back seat. And I think there's a good and a bad to that because there's more attention on Title IX than there's ever been, but it's been on one aspect of it, and some of the other aspects haven't received as much. But so we decided to join up with 4 or 3 other fellow states, Louisiana, Idaho, Mississippi, to challenge these regulations. We're represented as co-counsel by a nonprofit called the Defense of Freedom Institute, whose president and co-founder, some of you may know, Bob Eitel, was a senior counselor to Secretary DeVos and was also a key architect of the 2020 rulemaking. And so we filed our lawsuit the very morning that the regulations were published in the Federal Register. We literally could not have filed them any sooner. So I'm going to go over briefly the claims made by the states and discuss what's in our complaint, what's in some of the other complaints. And just as a caveat, from time to time, I might use a legal term or say something that's unclear. So feel free to ask me to elaborate when we have a discussion later on. I always say that most lawyers couldn't get PhDs or MDs, so we make up for that by using legal jargon to sound smarter. So happy anything I say that you want to discuss or explain later, make sure to save that for the Q&A, and happy to go over it. I think you can put the legal challenges more or less into 2 buckets. And the first bucket would be substantive challenges, and that has some subcategories. And then the second bucket would be procedural challenges. So the first bucket, these are arguments that the rule does something illegal or not in accordance with law. And Teresa mentioned the Administrative Procedures Act. Because this is a federal rule, challenges to federal rulemakings go through a statute from 70 years ago called the Administrative Procedure Act, and that's how you challenge agency action. And I've grouped these substantive challenges more or less into 7 categories, although it's by no means exhaustive, and some of them sort of overlap. But the first major category, and I don't think this is a surprise, is that the rule illegally incorporates the concepts of sexual orientation and gender identity into Title IX. And that itself violates Title IX, and every lawsuit has this claim. So they've said that the term sex includes the concepts of sexual orientation and gender identity. Wrapped up in that, you have the various arguments that forcing females to compete with biological males denies equal access to education programs, and forcing boys into girls' locker rooms constitutes a Title IX violation. Second, you have claims by states in general that the rule forces states to implement a federal program that conflicts with state law and forces the state to violate other constitutional rights. I'll get into this in detail a little bit later, but the idea is that states are accepting federal funds and of course have to comply with conditions, but those conditions can only go so far, and states have to be put on notice of what those conditions are when they accept the funds, and the federal government can't change the terms whenever they feel like. The third is a non-delegation doctrine claim. That's kind of a wonky term, but the idea is that even if the Department of Education has the authority to redefine sex under Title IX, then that illegally gives them the power to make laws. And Congress, of course, is the one that gets to make laws, and there is a level of interpretation and rulemaking that's allowed by federal agencies, but the courts occasionally will step in and say, Congress, you cannot delegate that much authority to an agency. And we've made the argument that this is one such case. Fourth, you have claims that forcing students and teachers to use preferred pronouns violates the First Amendment rights of students and teachers. Those are mainly made by private plaintiffs, but that's part of the state's arguments. In Montana, we have a statute that explicitly says that students and teachers cannot be compelled to use pronouns that do not match a student's biological sex. Fifth, you've got claims that it illegally lowers the standard of liability that Teresa talked about for sexual harassment. Sixth, you've got claims for vagueness, saying that these various provisions lack objective standards. This is going to get into some of the procedural claims that I'll discuss a little bit later. And seventh, you have claims that this violates due process and reinstitutes the kangaroo court system that Teresa talked about. And most of those claims are made by nonprofits and private plaintiffs. And I do share Teresa's concerns, as I said, about the due process aspects taking a back seat. One of the challenges for the states, though, and not to get too wonky here when it comes to legal jargon, is that to challenge some of these provisions, an entity has to have what the courts call standing. And that's the Constitution's requirement that to challenge a law or regulation, you have to have skin in the game. You have to have a legally protected interest. And us lawyers, we spend days and nights thinking of ways to, when I sue the federal government, I think of all of the different ways that I can find standing. And when people sue the state of Montana, I find as many different ways to keep them from having standing. So it's one of the challenges that there are so many terrible aspects of this rule. The states are in a great position to sue over some of them, and private plaintiffs and organizations are in a better position to sue over others. And happy to discuss those a little later on in the questions. So the big fish out there, as I discussed, is incorporating sexual orientation and gender identity into the definition of the word sex. There are various legal doctrines out there that we can use to debate whether the term sex from 1972 includes sexual orientation and gender identity, and how much deference the courts will give to the federal government to define it that way. The doctrine that we are relying on primarily, other than simply just the plain text of the regulation, as it would have been understood in 1972, is something called the major questions doctrine. And to keep it very simple, this is the idea that major policy decisions come from Congress, not federal agencies. Justice Scalia famously said, actually in a non-delegation doctrine case, but just forget that for a second, that Congress doesn't hide elephants in mouse holes. If Congress wants to impose a giant sweeping national mandate or change the state of the law, Congress is just going to do that. They don't put out laws with vague terms and give the agencies the ability to turn around and then change the entire economy. This issue has come up in student loan forgiveness cases, the COVID eviction moratorium cases, the OSHA vaccine mandate cases. And you're looking for an area where the government has taken a statute that's been around for decades and then claiming some new broad sweeping power. And I think here, given the implications, the definition of sex is absolutely a major question, and happy to discuss that more in the Q&A. But one of the reasons why Title IX is unique compared to some of the other cases that have come up recently where the court has discussed the major questions doctrine is that it's a spending clause statute. And as Teresa discussed, Title IX, the states get billions. I think the numbers in hundreds of billions of dollars a year combined in federal funding. And by taking those funds, you agree under Title VI to not discriminate on the basis of race or national origin. You agree under Title II or under Section 504 not to discriminate on the basis of disabilities. And on Title IX, you agree not to discriminate on the basis of sex. And it's akin to a contract with the federal government, where the federal government says, here's a bunch of money, but it isn't free because of those conditions. And if the states don't comply, we're talking about tens of billions of dollars a year in federal funding at risk. And the Supreme Court has said, well, the federal government gets a lot of power. It's very broad, but it's not unlimited. And you can't surprise states with what the conditions are, and you can't do it in a way that coerces them. And I think that there's absolutely no way that these conditions were clear when the states accepted the money. And it's not good enough for the federal government now to say, well, you're on notice. The original public meaning of the term sex in 1972 is the same as it's been from the beginning of time, male and female. And the Department of Education can't simply redefine that and say, if you want to continue receiving our money every year, you have to agree with our definition. That's just simply not.
I think I've said it's like a new contract,
It's a new contract, and they've said that. But our point is, particularly in light of the major questions doctrine, that they can't simply change the terms of the contract just because the funding comes every year, especially because the statute came in 1972. There are other cases, for example, in the Obamacare case, where the states looked at coercion, and you look at, well, even if it's a new statute, are they coercing the states into adopting a particular type of policy? And here I think you have that point, because you have the federal government telling the states, now you have to, one, violate state law that requires males and females to participate separately in athletics. You have laws that prevent biological males from going into female locker rooms, all of those types of things. And now you have the federal government saying, comply with our mandate and our agenda, or you can't have our funds anymore. So moving next to the second big bucket, and these are the procedural requirements. The APA, Administrative Procedure Act, prevents agencies from making decisions that are arbitrary and capricious or an abuse of discretion. Legal jargon aside, what this means is that agencies have to explain their decisions. They have to put forth rules that are internally consistent, and they have to show they meaningfully considered input from the public during the comment period and explain what they did and why they did it. And as a background, for the DeVos rules, I think we had 120,000 public comments. The Biden rules doubled that. It was over 200,000, I think, approaching close to 240,000 comments. As I said earlier, the concept of gender identity and women's sports just ballooned the topic and the number of comments in a way that I don't think we ever could have imagined when we were promulgating the 2020 rule. So the first big liability that the rule has is for all of the talk about gender identity. It doesn't even define what gender identity is. So it's not just, okay, men becoming women and women becoming men and vice versa. It's many other things. I mean, I think as folks see out there, I don't actually know exactly how you can define gender identity, because I've seen some lists that say there are 107 genders. Others say there are more than that. With something so subjective that can cause a recipient to lose their federal funding, they didn't even bother to tackle that. And admittedly, that's a core problem with the entire concept of gender identity, is that it's not anchored in anything. It's not anchored in something like, say, biological sex, male and female. Some would say, and I would agree, that that's the whole point of sex just being male and female, is that it's fairly easy for even us simple lawyers to understand the concept. Now, I'll tell you why this is particularly interesting. So they feign sort of ignorance as to exactly what gender identity is, although they essentially say they know it when they see it. But part of the reason they claim that they have the ability, or that they should have deference on defining sex under the statute, is that the department has expertise on how to define sex discrimination. So the department says, well, we have expertise on how to do this, and Congress and everyone else should defer to us because we know it when we see it, but also we can't actually define what it is. So it leaves recipients from school districts all the way up to colleges and universities left at the mercy of OCR, Title IX coordinators, and other individuals and activist groups, frankly, who are going to be pressuring the department to take action and filing complaints. And as I mentioned, there are some vagueness challenges. This overlaps because, of course, if you don't know what conduct is prohibited, you don't know what you actually have to be worried about. Another procedural aspect that I think leaves the rule that we've alleged that leaves the rule susceptible is the athletics rule that Teresa mentioned. So originally in September 2022, the department, earlier in 2022, the Department of Education, promulgated this Title IX rule, and then they said, well, this doesn't technically cover athletics. We're going to do a separate rule later on. The skeptics and cynicists in us said this was definitely an attempt to punt this until after the 2022 midterm elections. And so they ended up very shortly after that putting out a separate athletics rule, which they say is not covered by this rule, by the Title IX rule that's already been released. Now, that's problematic for a lot of reasons. First, there is no rational way you can read the Title IX rule that's out and say this doesn't cover state laws and regulations with men and women's sports, et cetera. It absolutely does. And of course, again, I think there's politics at play here. The athletics rule has not yet been released. We don't know when it's going to be released. And again, some of us are pretty sure they're going to wait until after the 2024 election to release it, but we'll see. And so one of the procedural arguments that we've made is you put forth these two separate rules that are internally contradictory. And then once the athletics rule was out, you only gave us the ability to comment on the athletics rule. You didn't give us the ability to then further comment on the existing Title IX rule to explain to you all of the different problems that this new athletics rule created.
I'm sorry, Christian, when you say they're contradictory, you lost me there. Could you back up and explain that?
Yeah, so there are provisions within. So first of all, just at a very, very basic level, there's no way to read the athletics rule sort of punts the issue, the proposed athletics rule. We don't know what the final one's going to be.
Right.
But the proposed athletics rule says things like, well, this is going to be judged on a case-by-case basis.
Right.
We're not going to impose a categorical rule. Now, when it comes to the current Title IX rule, it talks about, well, as long as if it's anything more than de minimis harm. Well, those are very difficult concepts to square. But also, there's absolutely no way you can read them, their guidance, or read the actual text of the statute talking about importing Bostock and say that state laws that prevent men from playing in women's sports across the board don't constitute more than de minimis harm and don't flat out violate the rule. And so the other thing is you're going to get legal challenges down the road that even if the department takes a particular view, certain groups are going to file lawsuits and say, regardless of what the department says, if you're incorporating Bostock and the Department of Education is correct, there's absolutely no way Montana's law and the 20-something laws passed by other states can withstand it. So the rule is in tension.
Christian, since you mentioned the Bostock decision, do you want to do a quick recap of its relevance for Title IX?
Yeah, and to be fair, I'll sort of
relevant for Title IX. That's an open question.
Yeah. So several years ago, under Title VII, which prohibits discrimination in employment, the U.S. Supreme Court ruled that sexual orientation and gender identity discrimination were covered under Title VII. You had a transgender individual who wanted to dress like a man or woman, and the court said that an employer refusing to let a transgender male, dress like the gender he or she identified with constituted impermissible sex discrimination. And so I talked to everybody a little bit earlier about, well, they're just totally changing the concept of sex from what it meant in 1972. One of their arguments is, well, Bostock changed everything. We are bound by the Supreme Court's decision in Bostock, which says sex covers sexual orientation and gender identity. There's nothing we can do. There's Supreme Court precedent. Now, the arguments against that, which I think are pretty strong, is if you read Bostock, the court made very clear to point out that Title VII and Title IX were different statutes, and the holding was limited to Title VII. Bostock's reasoning was also based on the concept of biological sex. It wasn't actually based on the concept of gender identity. It was that an individual is being denied the right to dress a certain way because they identify as a man, and if that individual had been a biological woman, they wouldn't have been prohibited from dressing them. So there are some very strong arguments why Bostock doesn't apply. Also, there are textual arguments about Title IX. It's an entirely different statute. In fact, Title IX actually discusses sex-separate facilities, sex-separate activities. The whole point was that it was supposed to ensure equality between the sexes, and realizing that, for example, when it came to athletics, you might need to have sex-separate activities so as to provide equal opportunity for women in women's sports.
Yeah, so just to recap, a lot of the Biden administrators are rationalizing their imposition of same-sex orientation and gender ideology by citing the Supreme Court Bostock case, Bostock versus Clayton County. Yep. That case, however, involved a completely different federal law, a ban on sex discrimination and other forms of discrimination in employment, yep, which is different from the context of education. And the court itself, in that opinion, said the opinion was limited to Title VII. So there is an implication of bad faith here, I think, on the part of Biden administrators. No surprise there, abusing, citing a case that doesn't stand for what it claims it stands for. Okay, sorry.
Yeah, I think that's exactly right. And I think that's the refusal to recognize that these two statutes, yes, they both use the word sex, but they're worded differently, and they cover different aspects. And as I think everyone here knows, schools are not traditional workplaces. They're not, whether it's K through 12 or higher ed, they have the statutes covering employment discrimination are entirely different than statutes covering race discrimination and sex discrimination, and they have different purposes. And we've made the argument repeatedly, and of course the federal courts are going to decide, which is what I'll get into now, that they should be evaluated differently. And discrimination in one context doesn't necessarily mean discrimination in another context. So getting to that, so we've asked the court to issue what's called a preliminary injunction. This means, as everyone here probably knows, lawsuits are not quick endeavors. They usually take several years to complete. So what we did is to sort of speed up the clock. We filed a motion for a preliminary injunction, which essentially says to the court, if you don't temporarily enjoin this law during the pendency of the litigation, the state and the private parties are going to suffer immediate and irreparable harm. And for us, we think it's pretty simple. The law goes into effect August 1st. If we do not comply as of August 1st, we are at the risk of the federal government coming and pulling billions of dollars in federal funding. And so some of the determination of our pending motion, of course, falls on the merits of the case. So we, when you brief these, you usually get an indication from the trial judge on how he or she feels on the merits of the case. And then oftentimes after a preliminary injunction is either issued or not issued, either party will appeal to the Court of Appeals. And it's a way of sort of fast tracking the case. And I believe every other Title IX lawsuit, at least the ones that were filed by the states, also has a pending preliminary injunction motion. As far as timing goes, ours is fully briefed. Several of the other ones are fully briefed. I think several of the others after that are being completed now. I would expect in the next few weeks, you are going to get orders from at least one, if not more, of these district courts. And I would, if I was a betting man, I would tell you that at least one of them is going to rule in favor of the plaintiffs. Now, this gets a little complicated because sometimes a district court that issues a preliminary injunction will say, I'm going to issue this for everybody nationwide, and the Department of Education cannot enforce this against anyone. Other times, it will say, I'm only going to keep the Department of Education from enforcing this against the particular plaintiffs in this lawsuit. So, for example, if we were successful, the judge might say Montana, Louisiana, and the 18 school districts that joined us in other states, the department can enforce it against everybody else, but cannot enforce it against you. And so that's where things get a little bit complicated. And
Christian, let me interrupt here for a second because you speak so quickly, and we're now getting into the current moment. So Christian reports that his complaint with Montana and Mississippi and the two other states has requested of the trial court that the Biden rule not take effect. That's called an injunction, and they've requested an immediate injunction, what's called a preliminary injunction. Christian also says that the 8 other lawsuits have done the same. All have requested preliminary injunctive relief. Christian has already filed what's called a brief in support of that request. It was opposed by the Biden administration, and he filed his response. And we don't know if there are going to be hearings in Louisiana and in the other states, but we think over the summer, these 9 lawsuits will all have to address whether the Biden rule does or does not take effect. But it gets more complicated because a trial judge technically doesn't have the jurisdiction or competence, this is the conservative in me, to issue an injunction for the entire country, a single trial court judge. That just defends common sense. So then the question is, what is the scope of an injunction that would be issued? And then is this the Fifth Circuit? I'm sorry, the Louisiana, is that the Fifth Circuit?
It is.
Okay, so if the trial court issues an injunction, Christian, would that apply throughout the states in the Fifth Circuit? And likewise, for the other lawsuits, if they were successful in getting the rule delayed that is enjoined, would that also be the states within the federal circuit?
So on appeal, so you're asking, so what Teresa's asking is if Montana is successful and it gets appealed to the Fifth Circuit, which is the Court of Appeals right above the Louisiana District Court, if the Fifth Circuit says, hey, district judge, you were right, does that apply to all the other states, even if they were not? So the one other state that would be included that has its own Fifth Circuit lawsuit would be Texas. What the Fifth Circuit can do, it can broaden the injunction or it can narrow the injunction. I will say there is a parallel lawsuit in federal district court in Texas. So in the event, what usually will happen is the Fifth Circuit, the Court of Appeals won't broaden the injunction, but given that there's a parallel lawsuit, once the Fifth Circuit rules on that, if that district court has not already enjoined the law, the lawyers for the state of Texas and the private plaintiffs will file a notice of supplemental authority and most likely ask for an immediate temporary restraining order to say, the Fifth Circuit has ruled on this, you have to rule the same way because we're going to suffer irreparable harm. Now, if you're not in a circuit that is covered by one of these injunctions, unfortunately, if you live in California, Montana's in the Ninth Circuit. We are fortunate enough to be filing in Louisiana with our sister states, but like Idaho is, if you may be unprotected. Ultimately, the Supreme Court's going to have to decide this case, and I imagine it will do so fairly quickly. I think I see a question in the chat about that. I see SCOTUS there, so I assume that's part of the question.
We can address that now since we're on that point. If Montana and the other states don't win in federal court and appeal to the circuit Court and also lose, are you all planning to take this issue to the Supreme Court? If the Supreme Court agrees with the state's position, how will it affect Bostock?
Yeah, well,
I ask this because Bostock in many respects affected my fiat, what employers and later on public institutions, how they deal with persons who claim they're of the opposite sex. How are religious persons' institutions going to be protected?
yeah. So first of all, yes, and it's probably a race to get to the Supreme Court. Whether it's the state, one of the states that ultimately loses, or it's the federal government, someone is going to ask the Supreme Court for emergency relief, and the court is going to have to take this case. This is I mean, the only other lawsuits that I can think of that generated this number of, the only other issues, this number of lawsuits from the states were the COVID vaccine mandates.
Yeah.
And really that was the circuit lottery where everybody filed in all the different circuits, and there was literally a ping pong ball lottery in 2022 of which circuit it was going to fall into. This is the most controversial, most high profile rule coming out of the administration. And yeah, the Supreme Court's going to have to take this. Whether they take this on what's called an emergency posture, or whether they sort of take one of those emergency applications and say, okay, there's 7, 8, 9 of these pending. We're just going to put this on our term for next year, or the next term. They're going to have to take it up. As far as what that means for Bostock, well, probably depends on what the court does. There's a lot of, I mean, listen, there are a lot of arguments you can make that say the court can carve Title IX out, and Bostock and Title IX can coexist in the same world. There are arguments, I think, from maybe both sides of this that say Bostock and a decision striking down the Biden administration's rule are in tension. That I think the left certainly argues that, and I think there are some on the right that argue that Bostock really shouldn't still be good law, and that the court got it wrong however many years ago, and that we do have a different court than we did then. So it'll be very interesting to see. I think it comes down to the details of how the court deals with Title IX. I think there is a world in which they can coexist, but there's also a chance that the majority opinion, it would probably be a 5-4, given who the justices are, decides that there's tension even between Bostock and whatever the name of the new opinion is. As far as the religious institutions and people of faith, I do think that as far as individuals, there is a lot of concern about being compelled to use preferred pronouns and being sort of forced to adopt this. One good thing about Title IX is that there is a statutory exemption for religious institutions from Title IX. Right. So institutions, if to the extent one of these is not consistent with that institution's tenets, there is an exemption for Title IX, and there were a number of lawsuits, particularly right out of the gate in 2020 and early in 2021, against religious institutions.
I know they're going.
Teresa's probably familiar with these.
They want to eliminate the religious exemption.
Yeah, exactly.
So
essentially tried to argue, I think one of them was that, well, the religious exemption is inconsistent with Equal Protection Clause, so it needs to be eliminated. But fortunately, even courts in the Ninth Circuit actually disagreed there. A lot of the lawsuits ended up being stayed and going away because the department was promulgating the Title IX rule.
Right.
But yeah, it's a real concern.
The Supreme Court can't issue an opinion until next year at the earliest. So the big question is this upcoming academic year, and is the answer, we don't know.
Yeah, I think that's right. I think we don't know. Now, listen, you could have as the court is in June, always finishes up and issuing its opinions, and it goes on summer vacation for July, August, and September. Although it does meet a couple of times to decide, whether it's going to take some cases. But in general, the court is not going to start hearing cases again until the October first week in October. So, however, there of course is what they call the shadow docket or the emergency docket. So there certainly is the possibility that either a state or the federal government asks the court for some type of emergency relief, which would be what we call a stay, which is essentially, hey, this court has issued a ruling that's going to harm us. Can you put it on pause for the time being while the appellate courts and ultimately the Supreme Court decide what's going on? I think whether that happens is your guess is as good as mine. This is it's a little bit chess and it's a little bit backyard football at times. You never know how things are going to go, and it's all about what court issues a ruling when and what the different parties decide to do.
Yeah, just picking up on a couple points, there was a case, I think it was Shawnee State University in Ohio, a professor who was being forced to use pronouns and he sued and he won. So there's that legal authority to say that forced speech, forcing people to use these pronouns against their conscience is not constitutional. At least we have that case. You're probably also aware, Christian, of the Taft College in California resolution agreement, where the education department, even before this rule, is behaving as if Title IX requires this forced speech. They disciplined administrators at that school and came up with a resolution agreement, which, did I mention bad faith?
Yeah.
I mean, because on the one track, they are formally promulgating a regulation to require this, but on a completely separate track, they are behaving as if Title IX already does require. I mean, this is what's called speaking out of both sides of their mouth, and bad actors. And I'll make an additional point. In my background section, I mentioned that bureaucrats in DC and on campus are responsible for these expansions. It's important to realize these people are on the same team, that you have DC Biden administrators, but they have their partners in crime on the ground who are getting their marching orders, regardless. I mean, regardless of whether a rule has been formally promulgated, possibly regardless of a court ruling. I mean, we're getting into, given how much attention this space gets, you would think that bad action of that sort would stop, because scrutiny is the best check on these ideological excesses.
Yeah, I totally agree. And I think this rule, there are so many, and we don't even have time to get into the nuts and bolts of some of the aspects of this rule. But this rule sets up a system where the Title IX coordinators and all of the activists that are in institutions are going to police speech, chill it, and do it in a way that leaves anybody who believes in the basics of biological sex, male and female, afraid to speak their mind. And one of the things I always try to stress about this rule is you take the new definition of sexual harassment, you take the expansion of the powers of the Title IX coordinator, and then you take the lack of due process proceedings, and you get this scenario where all of the terrible things that happened under the Obama administration, and you think about what happened, the famous scenario of like Professor Laura Kipnis from Northwestern, who was, subject to Title IX for writing an op-ed in retaliation for writing an op-ed in a public newspaper. This is going to lead to whatever we thought of the system during the Obama era. This is going to make it 100 times worse. And it is going to create a scenario where Title IX coordinators and institutions and the Title IX bureaucracy are essentially going to be the speech police. And they've been empowered by the department to do it. And many of these people, as I'm sure all of you know, are ideologues. They are not, they are gender studies majors, social justice majors.
Yeah.
Some of them went to law school, and they are there to police speech and enforce an agenda. And it was bad enough before this rule, and it's only going to get worse afterwards.
Yes, the words commissar and apparatchik come to mind.
Yes.
You got the commissars in DC, the apparatchiks on the ground on campus. And now I'm thinking that the word bad, the bad Biden rule does not capture it. Abominable.
Yeah, it really is.
Abomination. You're right. Professor Kipnis, the best quote from her, I thought, was, "These people are drunk with power. They are drunk with power. Their power is not checked. You know, the American way is checks and balances. It's the check on government officials when they have power. But a lot of these executive and campus bureaucrats, especially on the ground, I think they just say, well, federal law requires this. I don't know if you were familiar since you were working with DeVos. There were states that defended the DeVos rule. I don't know. You're probably aware.
Yeah, Texas did, and a number of other states, I think, joined.
And they made the excellent point that schools constantly claim that Title IX requires stuff that Title IX does not require. You know, this is a power play for the campus bureaucrats. This is how they get their way, is that they say federal law requires it with no authority whatsoever that federal law requires it. So, for example, the latest from the Supreme Court is old now, 1999, and said conduct had to be severe, pervasive, and objectively offensive. But every school I surveyed tinkered with that language, severe or pervasive. So, severe or pervasive or subjectively offensive.
Right.
It was just the sleight of hand.
I think that what's important, I think your background of Title IX is very important because, the joke is, remember the old saying, let's not make a federal case out of this, that not every aspect of sexual harassment, not every offensive comment rises to the level of a Title IX violation, because even through the courts, despite it is something that has to rise to the level of denying someone equal access to education, right? And there are plenty of objectionable things that happen that schools can deal with under their own codes of conduct that do not qualify as federal civil rights violations. And I think, again, I'm glad Teresa covered it, because I think that always gets lost in this discussion. That everyone wants to go through this parade of horribles and discuss all these things that can happen and don't realize that this is how we got here. And I think that's really important to remember.
Well, I think it's related to the power hunger of the campus bureaucrats, because as you point out, schools can ban on their own gum chewing, loitering, spitting. They can, in their own student conduct code, they can ban conduct that they don't want. But what the Title IX bureaucrats do is claim that federal law bans this and the school has to ban it. So I think maybe another example of bad faith. Okay, let's see. These negative changes to Title IX started under the Obama administration. Biden is just taking it from bad to worse. Yes, it may even have started a little bit earlier than that. One last question, Christian, because I've been asked this, and I think it is confusing for most people. People do not understand how the Supreme Court had its last word on Title IX, describing just what you were saying, that not everything is a Title IX offense. They wanted to cabin in the type of conduct that could become a federal matter. And in that 1999 case, Davis versus Monroe, said that only conduct, not speech, that is severe, pervasive, and objectively offensive, such that someone is deprived of educational opportunity, constitutes a federal offense. And the question I get is, how can the agencies ignore that? And since the Clinton administration, I believe, the agencies have said, We can ignore that because the Supreme Court was devising standards to sue in
Private rights of
federal court.
action. Yeah.
Whereas we in the federal agency are devising standards for adjudications within the executive branch, investigations by the regional offices of civil rights and campus adjudications. Now, to my mind, as an attorney, this is a huge question that is screaming for resolution. What do you think?
Yeah, absolutely. I think, yeah, certainly. So the federal government says Gebser and Davis from the 90s, this was all about a private right of action. And when a student can say, I was harassed, sexually assaulted, and my school did nothing about it, I'm entitled to money damages. And the school and the court said, yes, we need to look whether the school had actual knowledge and did you act with deliberate and were they deliberately indifferent? But there's nothing in those opinions that purports to limit that standard to just private rights of action. They set it for Title IX. And certainly, I think the courts of appeals have agreed with us, but that's when this ultimately gets up to the Supreme Court. That's of course an argument that the court's going to have to deal with and decide.
Are you going to raise this issue?
Oh yeah, and all of the groups to one way or another have raised this. I do think that this gets back to this idea that the agency says we get deference because we're the experts. We know how to prevent sex discrimination. So just because a private right of action on one hand, the courts say, this is the standard, we get to tell schools how they can prevent sex discrimination because we know how to do it best.
Yeah, the expert, they're playing the expert card.
Yeah.
Well, the good news, there are two items of good news in addition to the state stepping up so brilliantly to check the Biden administration. The first is that the courts are, as I mentioned, increasingly aware of executive agency overreach. We now have the expression, the administrative state. At George Mason University here in Virginia, there's an entire institute that tries to police what these agencies are doing, and that is all to the good. Sunlight is the best disinfectant. You need more people paying attention to these shenanigans. And I mentioned, I think to you yesterday, that the United States Congress, the House of Representatives introduced House Joint Resolution 165, which expresses disapproval for the Biden rule and ends with, and such rules shall have no force or effect. I believe this is the beginning of Congress exercising its oversight powers pursuant to the Congressional Review Act. And I don't know that Congress could have a veto-proof vote to reject the rule. I don't know if you want to contribute here, but at least it's a good development that members are going on the record. And as you say, Christian, a lot of this is sort of the chaos, the gender bending, the athletic stuff that has received so much attention, even though we want to make sure that due process remains on everybody's radar, because if that gets on the QT, that'll be another nightmare. It'll be the DC 2.0.
Yeah, absolutely. And as background, there's a statute passed during the Obama administration called the Congressional Review Act, and it allows any rule that comes out of what they call a significant rule that comes out of an administration within a certain number of days of that rule coming out, Congress can vote on that rule and repeal it as long as the president signs it. Now, why, you may ask, well, what's the difference and then Congress just changing the law? Well, number one, under the Congressional Review Act, reviews of these regulations are not subject to the filibuster, which is obviously big. And I think that particularly in an election year, when you have a number of vulnerable senators, the fact that the Senate will actually have to take a vote on this, despite the fact that we know President Biden will not sign a repeal of his own rule. Also, for those of you following, there have been a lot of regulations coming out of the federal government recently. Most of those were to beat the Congressional Review Act deadline, meaning that anything published this year after a certain date, in the event that Donald Trump were to win the 2024 election and Republicans held Congress, they would be able to repeal a lot of the rules that come out later this year, as they did in 2017 following taking office. So it's a positive development. I think that there are a number of vulnerable folks in Congress who don't want to vote on this, and getting them on the record as to where they stand is really important, and hopefully can build some momentum.
Yes. And one last thing, I know I said that before, so call me a liar, but you said the state laws were an issue in a lot of these complaints.
Yeah.
Are these state laws protecting athletic teams? Are these state laws defining sex? What are the state statutes at issue?
Yeah, so I can, they generally, I'd probably put them into three categories. The first would be the Protect Women's Sports Act, which prevent biological males from competing in women's sports. The second would just be, like in Montana, we have a bill that just expressly defines male and female by statute as what it's meant since the beginning of time. And when you're challenging us, if you want to change your birth certificate, et cetera, you have to run into our state statute that says that. And then the third category would be what I talked about earlier, which would be conscience statutes, which say that teachers, students, professors, parents, whatever it is that are involved in education, or beyond that, if it's a much broader statute, cannot be compelled to use preferred pronouns. Or, for example, one of the hypotheticals we've talked about is, what if a statute requires parental permission for a student to use their preferred pronouns? There are arguments that the Biden rule would actually conflict with those state statutes as well.
Yeah.
And so those are the different types of statutes. And, the states in 2021 did exactly what states are supposed to do when they saw a federal government encroaching and saw this sort of new gender ideology movement coming at the states, and they passed laws that that we wanted, that their citizens and wanted, and to protect the states. And certainly it set up a big conflict with the federal government. But that's what states are supposed to do, and it's helping us in our litigation, and it's helped our our citizens.
Well, so it was time well spent. I mean, congratulations to the states for stepping up and passing laws in light of, these developments with gender ideology. One last issue we didn't cover has to do with the procedures, the clinical procedures that what I would call mutilation, genital mutilation. Yeah. That's more at the clinical, in the clinical setting rather than the education setting, but perhaps for medical schools, have you heard of any of the potential fallout for clinical training and medical education in Title IX?
Yeah, so this overlaps really nicely. If I can plug another lawsuit, we just filed suit against the Department of Health and Human Services Section 1557 rule, which requires states to cover gender transition surgeries. And Section 1557 is based on Title IX. And so one of the state of Texas got declarations from, I believe it was Texas Tech Medical School, saying that this is going to force us to cover all of these procedures that are banned by, particularly for minors, that are banned by state law. And Montana has a similar law that doesn't allow those types of treatments for minors. And so the laws are, Title IX, it really is a very far-reaching statute. A number of federal agencies from NASA around have non-discrimination provisions in their grants, and they're all based on Title IX. And so
sort of an incorporation by reference. They just index their definition.
And so Title IX is a far-reaching statute, even just beyond what we think of colleges and universities, higher ed, and K through 12. It really is a statute that's been incorporated into federal law, which is why there have been so many different rules coming out trying to take Bostock and apply it to every single aspect of the federal government.
Yeah. Well, no shortage of work for you.
Yeah.
All right, well, we've been going for over an hour. I don't see any more questions coming in. So, Christian, I can't thank you enough for sharing your time and your expertise with us. Do you have a sense of amicus brief, friend of the court briefs? Are you looking for those?
Yeah, absolutely. I think ultimately where amicus briefs are usually the most prevalent are inevitably when this goes to the Court of Appeals, and then the Supreme Court, which will be a free-for-all. I mean, there will be probably hundreds of amicus briefs on both sides. But yes, to the extent folks want to help or want to be involved, there are obviously a lot of nonprofits and groups involved in litigation, but there will be even an even greater number filing amicus briefs. And so, that is always very helpful, both on substance and just from the appearance that, our side isn't alone. It's
right.
It
does matter. Yes.
The other side is very well funded and will have plenty of pro bono attorneys at big firms writing briefs on behalf of all of these organizations on the other side. And I think it's very important that our side is equally represented. And so folks, do not shy away, and don't be afraid of standing up and to these rules and fighting.
Yeah. So to recap the to-do stuff for the academics who are NAS members, there's not much that can be advised because we don't know what's going to happen this summer. Many requests for the Biden rule to not take effect and just follow the website of the National Association of Scholars because we will be monitoring that situation. Second, a great thanks to all those citizens who did state level activity. The state statutes are playing a big role in this litigation, protecting free speech, protecting women's athletics. So these state laws really do matter. And finally, for the litigation, if anyone's listening and is part of a nonprofit or able to file friend of the court briefs, Christian thinks those really help. They're typically done at the appellate level, but also, of course, at the Supreme Court level, which will probably get hundreds, given how controversial and how much attention this rule has received. So I think that wraps it up for us. Many, many thanks. I think we'll be in touch in the future. Christian, thanks for your service in the Trump administration, your hand in the DeVos rule. Thanks for what you're doing now on behalf of the state of Montana and all sane American citizens.
Well, thank you so much for having me. It's been a pleasure. And to all your members, thanks for everything you do. And glad to be here and hope I was able to help shed some lights. And thanks to you, Teresa, very much.
Yes. Okay. Well.